Our next case this morning is Washington Association of Counties versus State of Washington. We're ready when you are, Mr. Lawrence.
Great. Thank you very much, Your Honor. Paul Lawrence for the Washington State Association of Counties and the individual counties. The counties here are challenging the constitutionality of the state's statutory scheme, whereby the state has delegated its constitutional obligation to provide counsel to indigent criminal defendants to the counties. Specifically, we're arguing that the statutory scheme fails to provide the counties with the means necessary to furnish constitutionally adequate indigent public defense services. This is exactly the claim which the state Supreme Court in the Davidson case said would be the only basis to attack the state and on the issue of whether or not the state was adequately supporting its constitutional obligation.
Of course, in Davidson, the plaintiffs were not counties. They were the actual criminal defendants, right?
That is correct, but that has nothing to do with the rationale of the court's holding, which was that there is a single claim for liability, and it has to be doing the attacking the statutory scheme as opposed to a knowledge issue. The statutory scheme is a scheme that directly implicates the county's interests because it's a statutory scheme that sets up that delegates the 100% of the obligation to indigent criminal defense at the trial court level to the counties.
Is that the zone of interest analysis, though? Because in at least some of the state Supreme Court cases, the question for zone of interest is looking at the constitutional or statutory guarantee that's relied on in the complaint, and then looking at the zone of interest of that guarantee. And here, the complaint rests on equal protection, right to counsel, right? So my understanding from in the zone of interest analysis is that we have to see is that the counties are within that zone of interest of the claims made in the complaint. So can you help me understand how we get there?
Sure. I think the Seattle School District case gets you there 100%.
So assume that I have doubts about Seattle School District because there, the constitutional provision is actually a funding provision, right? So it's very, I can see the zone of interest quite more clearly, right? It's not one step removed. So help me understand sort of without that kind of claim where you don't have an actual funding provision in the state constitution that's being relied on, that ample provision language, how you get to the zone of interest.
Well, two things. First of all, you start with the fact that this is a federal constitutional obligation. Right. It's on the states. The states have to provide this. So whether the states provide it directly or through counties or consortiums of counties, it has to be provided, and that implicitly includes funding mechanisms to make sure that the level of services being delivered are sufficient to meet constitutional standards.
So you're saying it's just as good as the ample provision language in the state constitution for education funding because it's implied through this federal requirement on the state.
Right, and okay. I think that is implied because it's a very unique obligation to provide indigent criminal defense funding. Most of the federal constitutional things are, you can't do this, you can't do that. There are very few things that say to the state, you must do X. And this is exactly that type of constitutional obligation.
So what do we make of the Supreme Court not really making that step in Davidson, not answering the question of whether it's a positive right or not?
I think as you saw, we argue that it is a private right, but I think it's irrelevant to the ultimate conclusion here because the Supreme Court in Davidson, as well as other cases, have made clear that this is an affirmative obligation of the state. I don't know what the difference could be between a positive right and an affirmative obligation of the state, but something that requires the state to do something. And again, the way that it's been described by the federal courts, the U.S. Supreme Court, by commentators, this is whether you call it a positive right, it is certainly not a negative right. It is an obligation that's put on the states.
So what's your answer to the state's position that this is not like Seattle School District? Because Seattle School District, those districts were solely there to fund, to provide education. The counties are doing a whole lot more, including funding prosecution. Why is this not different?
Well, it's very different. I mean, it isn't different, I guess I should say. You're asking why it's not different. It isn't different. First of all, there's nothing about the decision in the Seattle School District case that rests on the special, that a local government being of a single purpose. I mean, in the City of Seattle case involving the Board of Equal Protection claim, standing was allowed even though the City of Seattle is a general purpose. I think the main point of what Seattle School District is about is that the obligation rested fully with the school district, and here the obligation under the state statutory scheme rests fully with the counties to provide this defense. Now, there will be issues, assuming we get to the merits of this case, the state will argue that, well, there's plenty of taxing authority. We don't believe so, but that's an issue to be decided on the merits of the case. It has nothing to do with the standing argument we face here. I also want to raise, we filed this morning as supplemental authorities related to the birthright citizenship case that the state filed against the Trump administration. In that case, involving the 14th Amendment, the state had no personal interest at stake. They have what they claimed to the federal courts, which is generally a harder standing provision, that their economic interests were harmed by the executive order, and that was sufficient for standing purposes. The federal government made the exact same arguments that the state is making here. They said, no. The 14th Amendment only gives individuals rights. It doesn't give states rights, and economics is not sufficient. But the district court, federal district court, held that the state had standing because of the economic harm it was suffering. It is not excusable for the state to come into this court and make arguments that are exact opposite of the arguments they're making in other cases.
Does the counties, are they alleging that the right to counsel is not being met? And if not, why isn't that required?
Well, as what we're alleging is that the system doesn't work. I don't think there's any dispute that the system is in crisis. Going back to the 1980s, there have been study after study after study by the state bar associations, by judicial administration, that the system is not adequately funded. And in each of those studies, it was determined that the state needed to up the funding to make the system work uniformly across the state.
But if you have, I'm sorry to interrupt you, but if you have, just because it's not working in terms of adequate funding to the counties, if every defendant is receiving adequate counsel, why is that not dispositive of whether a constitutional injury is actually occurring?
Well, I don't think we know that that's happening or not. There are lawsuits filed.
Do you have to plead that, though?
Well, what we plead is that we pled is that there aren't economic taxation dedicated to this to fulfill the obligations, especially as they are increasing over time. We know from what the Washington State Bar Association just adopted and what the Supreme Court said they're going to adopt over a 10-year period, the caseload standards are going down significantly. The costs are going up significantly. There's no money. Counties already are stretched. They've been identified, most of, 29 out of 39 counties are in economic distress, according to the state auditor. It just is not going to work. It's not working now. It's not going to work. And again, the allegations we make about harm have to be accepted as true. There's the same type of harm, again, that the state relied on in Trump. No one is saying the state can't afford to take on additional costs.
But don't you have to claim an injury in fact that's tied to the actual claims made in the complaint, which are right to counsel, equal protection?
No.
So don't you have to establish an injury in fact related to the basis for your claim?
Well, first of all, as this court held in the Seattle School District case, one of the things you look to are the school districts facing liability. The counties are facing liability. There have been a number of pieces of litigation that have been filed against the counties. There's one currently filed that we submitted as a supplemental authority against the county of Yakima. So we're facing exactly the same types of liabilities that were found sufficient in the Seattle School District case to show harm and to assert standing.
So the state says it's just a budgetary problem. You can move money from something else. Why is that dispositive of whether there's a constitutional injury here?
Well, first of all, on a 12B6 motion, you have to accept our allegations are true. They may be able to make that argument. We're not arguing the merits of that case at this point. What we're arguing is the ability to get into court to make that argument. They're going to say, look, there are all these resources out there. That's what they said in the McClurry case. But the problem is they're not. When there aren't resources dedicated, when it is clearly unpopular for people to vote to support indigent criminal defense, we have a real problem. We need to get into court, and we need to have the opportunity to prove it. And if we do, then get relief. But we shouldn't be denied the opportunity to prove it. Thank you.
Thank you, Mr. Lawrence.
Morning, Your Honors. Last year, Judge Zip correctly reasoned that despite the many challenges our state is having with public defense, this case was not the right vehicle to address them. He recognized that this was a case that explicitly invoked Gideon v. Wainwright and Davidson v. State, but did not include any Gideon or any Davidson. It was a public defense case that did not include a single public defender or indigent defendant in the courtroom. And although this state and this country have seen many systematic right-to-counsel cases brought, there's a reason you don't see them brought by political subdivisions, because governmental entities do not have any rights under the equal protection, due process, or right to counsel. These are not their rights. They are the rights of indigent defendants, and they are personally held for a reason. So there are two main reasons why county's case fails for lack of standing. The first is what I just said. These are not counties' rights. Counties have their own sets of rights. They have their own statutes and rights protecting their financial interests, but those aren't any of the rights being asserted in this lawsuit.
So, counsel, what do you make of the City of Seattle's sentence in which it says that protection of the integrity of the political process, as well as individual rights, is within the zone of interest protected by Equal Protection Clause? What do you make of that? It sounds like that expands zone of interest beyond just the individual rights.
So there's a few ways to look at City of Seattle, Your Honor. The first is that City of Seattle did not dramatically expand the scope of the Equal Protection Clause to allow any political subdivision to bring lawsuits. There really is no way to square that reading with the 2004 decision in Grant County, for instance, where a fire protection district tried to bring an equal protection challenge and was denied for lack of standing, or this court's decision in Kittitas County in 2020 when a county tried to bring an equal protection claim against a noxious weed assessment and was denied for lack of standing. What that is really showing in City of Seattle, Your Honor, is that in City of Seattle, there was an overlap of interest between those of the property owners who had equal protection rights and that of the city. And as the Supreme Court recognized in the Yakima County Supreme Court case, this is really a public interest case. There was a loosening of standing doctrine in that case because of the overlapping interest and because the city was able to have representative standing. But that's not being claimed here. There is no claim anywhere in counties that they are representing the interests of indigent defendants. They're representing their own budgetary and financial interests.
Isn't there an overlapping of interests here, though? At least, the county wears different hats, right? There's a prosecutor hat, but there's also the indigent defense hat. And don't they have a unified interest with criminal defendants while they're wearing their indigent defense hat?
Not with the context of these constitutional rights, Your Honor. Article 1, Section 22 is titled Rights of the Accused. The counties are the accuser. Indigent defendants aren't created until usually a county prosecutor brings criminal charges against them. And so, as has been stated numerous times over the past century, due process, equal protection, and as incorporating the right to counsel are all rights for indigent defendants to assert against the state when it is bringing criminal charges. So you don't have that overlap of interest like you had in Seattle School District. You don't have that overlap in interest like you had in City of Seattle v. State. And you don't have that overlap in interest like what you saw just from this morning's filing of State of Washington v. Trump, where the constitutional guarantee of the citizenship clause of the 14th Amendment actually does include both state and the interests of babies who are given citizenship when they're born. In fact, there were individual plaintiffs there, but there aren't any here. And that's the key point. The protections of Article 1, Section 22 of equal protection and due process are personally held, and they cannot be asserted vicariously. That was stated by our state Supreme Court in State v. Raffay, and it's been echoed throughout decades.
Well, they would argue they're not asserting rights vicariously.
Right.
They would argue that they're making a systemic change based on their demands that they pay for these interests. How is that not more City of Seattle? In terms of the broadening of the concept of equal protection to include the integrity of the political system.
Well, I don't think that's the basis of their equal protection claim, Your Honor. I think the whole basis of all their claims is that they're forced to pay for indigent defense when they don't think they're constitutionally required to do so. It's not, as Your Honors recognize, that every single county is unable to pay for indigent defense and is constantly violating the rights of indigent defendants.
So I thought their complaint had a bunch of information about the disparity among counties that presumably filters down to impact individuals within the counties. I think that might be what we're getting at when we talk about that overlapping interest.
There are some allegations about that, but I think the point is that counties cannot rest any claim to relief on equal protection. That's what was stated in 2004's Grant County decision by the Supreme Court. That's what was stated by this court most recently in 2020. And the City of Seattle did not just let every county bring an equal protection claim, and this court's decision in State v. Anderson so that counties also cannot bring any right-to-counsel claim. It's because these are personally held rights that cannot be asserted vicariously. If counties want to pursue to protect their budgetary interests, they have their own set of rights to do it. There is an unfunded mandate statute that they can assert. There is a constitutional provision that city sued under in City of Snoqualmie v. King County Executive Dow Constantine that protects their taxation, that protects their rights related to that taxation in Article 7, Section 1. And so they have rights they can sue under, but they just can't sue under these rights. These are personally held for a reason. And so this dramatic rereading of City of Seattle to give political subdivisions wide standing to sue because they can articulate some sort of financial imposition has been tried before in the nearly 4 decades since Seattle School District came out. I'm referring to Seattle School District, but City of Seattle also incorporated Seattle School District. It's been tried before and it's been consistently rejected by our Supreme Court and courts of appeals alike. For instance, in 2020, Lake Haven versus City of Federal Way, a decision that came out a week before Davidson, several water and sewer districts tried to sue a city over an excise tax it believed was unconstitutional under the Due Process and Privileges and Immunities Clause, arguing that Seattle School District, like counties do here today, gave them standing to do so. But the Supreme Court said no.
The Supreme Court said nothing about Seattle School District, with the exception of citing it for general propositions. It didn't address that particular argument at all, though, did it?
It didn't, but
how do we draw a lesson from that case with respect to the application of Seattle School District here?
It was raised in their briefs.
It was,
was.
Indeed. And they intentionally or unintentionally ignored it or didn't address it. So how does that guidance for us?
Well, the general principle is that they weren't within the zone of interest of those rights, and so their invocation was not sufficient to cover up the fact they didn't have standing to sue under those rights. But in other cases, there were direct reference to Seattle School District. For instance, in 1992's decision in City of Ellensburg v. State, where the city sued the state under Article 11, Section 11, saying that the state statute unconstitutionally obligated the city to pay for fire services for Central Washington, that they had standing to bring that lawsuit. But the Supreme Court said no. It said, and I quote, "Seattle School District involved the unique command of Article 9, Section 1 of our Constitution. It is not relevant here." And it's the same here, Your Honor. Article 9, Section 1 includes several bits of language that are not replicated in the equal protection due process or Article 1, Section 22's right of the accused. There is no paramount language that obligates the state to fund public defense over any other governmental service.
Are you suggesting that the right to counsel is not a paramount right?
It is not. It does not include the word paramount in it.
I'm not asking whether it includes the word. I'm just asking you if you think the right to counsel is not a paramount right.
It is not. Under our Constitution, it is not. There is only one paramount right. There is only one judicially enforceable funding duty in our Constitution. There is a reason Seattle School District and McCleary Courts both called Article 9, Section 1 unique. is because these terms do not appear anywhere else in our Constitution. There is no ample provision language in Article 1, Section 22 that obligates the state to directly give funds in any particular manner or above a particular threshold. There is no duty language in there. This is titled Rights of the Accused. It's fashioned as a negative right. And although counsel tried to say that Davidson said this was a positive right, the Supreme Court in Davidson very explicitly did not reach that. And so there's a second reason, Your Honor, that this is really an inappropriate vehicle, is because, like I said earlier, the right to counsel is a right of the accused to assert against the government. It's a fundamentally adversarial right that is asserted by indigent defendants against the county. By letting counties proceed with a case that will define the contours of this right, fundamentally reshape the public defense system, it essentially silences those voices without a single filing or giving any credence to the actual voices of indigent defendants who are right now suing to vindicate their rights over in Yakima County.
So, counsel, you made that argument in your briefing, and I was curious about it. Are you suggesting that the counties are solely interested in prosecuting crimes and don't have sort of a general interest in the quality of justice system in their jurisdictions?
That certainly is not their only interest, Your Honor, like it was for school districts who were mainly interested in getting funding so they could give schooling to their students. Counties have an interest in prosecuting crimes. They have an interest in creating indigent defendants by charging crimes. They have an interest in building up their, as we saw in the declaration they submitted, in building up their jails and building up their law enforcement capabilities. Their interests are really not coterminous with those of indigent defendants. Really, it's important for indigent defendants to be able to assert their own rights on their own terms by filing their own cases where they want, when they want, and how they want. This case eclipses that.
Hypothetically, had this complaint included a few plaintiffs who had successful ineffective assistance of counsel claims from the counties, the named counties, would that have allowed this lawsuit to get past the 12B6 stage on?
If this case had indigent defendants who were basically bringing the Davidson claim,
Right.
that, yeah. then
Incorporated within this?
This case would probably proceed, yeah.
Okay.
But they don't. This case was filed in September 2023, and not a single
In view
indigent
of the
defendant.
state, would the counties be an appropriate co-plaintiff, or would they
I think they
be
would
too
still,
adversarial to the plaintiff's claims?
they would still need to assert their own rights, but like I mentioned, there are rights out there that protect counties' financial interests. They're just not asserted here. They do not form any basis of this complaint as presented.
So counsel, before you run out of time, I want to hear why the sort of broad safety valve of issues of substantial public importance doesn't sort of get rid of all this, the entire standing issue.
Sure.
Yeah.
Your Honor, Judge Zip correctly reasoned that this was an inappropriate case for public interest standing for a few reasons. And the first is that the public important standing doctrine was not an invitation for every court to simply throw out traditional standing rules if it really wanted to. Where these cases are invoked is the directive given by 2004's Grant County decision, that they're invoked when there is a real risk that the issue will evade judicial review because the actual rights holders are not able to bring their own claim and their interests are adequately represented. Neither is the case here. Indigent defendants can and have brought their own lawsuits. They did it twice before in this case in the state with Wilbur and Davidson, and they're doing it right now in Alfaro v. Yakima County in Yakima County. And they've done it multiple times in other states. They did it on a statewide basis in Tucker v. State in Idaho. They did it on a statewide basis in Hurl Herring in New York. And they did it on a statewide basis in California, in Phillips v. California, and the numerous other cases that we mentioned in our brief. So they really are capable of asserting their own rights, vindicating their own rights. And so this case isn't necessary to address that issue. And I understand, I don't want to minimize or trivialize any financial difficulties that any county is facing right now. The financial realities of governance are certainly not beneficial on a state level or a county level right now. But this is not their case. This is the case of indigent defendants. And there's really no briefing here that's representing the voices or the interests of indigent defendants.
So if we assume the flip side, and I understand that case is happening, but if we assume the flip side, a case with counties absent, Is that realistic, given the sort of systemic nature of the claim? Can you litigate that case without the counties present to provide the kind of information that's suggested in the complaint?
Indigent defendants have successfully done this in other states. They were successful in Tucker v. State in transforming the state's public defense system without a single county being present there. They can do that here. But also, counties could be co-plaintiffs if they had their own rights or interests to assert, but they don't right here. This case is just resting purely on the rights of indigent defendants. It's being taken by a governmental entity against another governmental entity without a single public defender or indigent defendant in the courtroom. And this is precisely the situation our standing law guards against for good reason. Because when you have a situation with a right as important as the right of the accused, as important to their liberty interests, you cannot let another person gamble with the status of those rights to fulfill their own interests. And so as important as counties' budgetary interests are to them, it does not justify silencing the voices of indigent defendants here by letting this case proceed. Unless your honors have any more questions, I would urge the court to affirm the dismissal of county's case.
Thank you, Mr. Coates.
First of all, the state is not being honest with this court. They say unfunded mandates doesn't apply because this is not a mandate from the legislature that occurred since 1995. They say the birthright citizenship case involved individual defendants. It didn't when it was filed. And when the TRO was issued, there were no individual defendants in this case. And they haven't explained why that case is not determinative of the situation here. The issues before this court have to do with the statutory determination, delegation of the constitutional duty. Under the Washington Constitution, what is the supreme law of our state? What do we as a state have to follow above all other things? It's the federal Constitution. And it is a federal constitution that says states have to provide a public defense. This case will not be litigated unless this case can go forward. Since 1980, for 45 years, the issue has been out there that this is an unfunded, a not appropriately funded indigent criminal defense system. The state legislature each year refuses to do more. No case has been brought since Davidson that challenges on the statewide basis. 5 years ago, the Yakima case that was really filed didn't do that. This will not get litigated. And this is entirely a appropriate case. They're worrying about the rights of the perspective of indigent defendants. Well, what's happened in our state is very clear. Between the state adoption of WSBA guidelines and the state Supreme Court order, the contours of what an adequate criminal indigent defense system looks like is really 99% defined by those things. What is not defined and what is at issue and what needs to be defined is whether or not the statutory scheme that allows, that delegates this is appropriately funded by the state. And the indigent defendants have no information about that. Only the counties who are actually dealing with these budgetary issues and understand the state taxing power are going to be able to present that case. If this case can't go forward, it will never be litigated. We will have for the next 10, 20, 30 years continuing problems in the indigent criminal defense delivery systems in our state that the state has acknowledged in their own reports, but hasn't addressed for 45 years. Nothing is going to change until this case gets litigated.
So why can't a class action lawsuit from indigent defendants address these same issues?
Well, it could theoretically, but it hasn't. Now it's been 5 years. The ACLU chose not to proceed with that following the Supreme Court's decision in Davidson. They chose not to do that in the suit against Yakima. It is purely speculative. Plus, I don't think the ACLU would be able to do so because they don't have the information about the funding that is a critical element.
Why isn't that an issue of discovery, though? I mean, certainly capable class counsel for indigent defendants could do discovery on counties and get all the information about the funding mechanism.
They certainly can, but they haven't. And I think the problems with the funding issue are much more critical here because the state Supreme Court and the state statute adopting the WBSA guidelines define the contours of.
Where does the fact that this hasn't happened yet factor into the standing question?
Well, it certainly goes to the substantial public interest question, because this is an issue that has been identified in the state by the state's task force since 1980 that hasn't been dealt with for 45 years. This is an issue that no one really argues, and I can't believe the state would argue, is not a critical, important issue of public importance, whether or not the state is meeting its obligation to provide a constitutional adequate legal defense. It is clearly an issue of substantial public importance. It's clearly an issue that's been out there for 40 some odd years without resolution. It's clearly an issue that the state Supreme Court has identified can be litigated, but it hasn't been litigated yet. And the situation is only going to get worse because of the new caseload standards that are being adopted over the 10-year period.
Why isn't this a legislative issue? I mean, why do the counties go to the legislature and get it fixed?
We have tried every year for 40 years, and they have not done so. And to be clear, we're not saying that the state has to fund 100%. We're not saying that the state has to fund or that they have to provide it themselves. That's issues that will be figured out at the end of the case. It may be, for example, that it's only 50% funding, but we need the chance to litigate that, and this is the only opportunity to address the serious problems in the state. Thank you.
Thank you, Mr. Lawrence. Thank you, Mr. Coates. The remainder of our cases today will be decided without oral argument, so we will be at recess.
All rise. Court is now adjourned.